Associate Memo of Appeal.
Lordship, we apologize for the Lordship, 5 issues have been raised in the present appeal, whereas Lordship, I'll argue on the first 3 issues and my co-counsel will deal with further 2 issues. Lordship, with your permission, may I proceed for the arguments?
Please.
Much obliged. Lordship, the first issue in hand is whether the appeal is maintainable before the Honorable High Court. Your Lordship, the Council of Appellant most respectfully submits that the present appeal is maintainable before this Honorable Court under the Indusland Nadi Suraksha Samhita 2023 and Constitution of Indusland. Your Lordship, Section 415 Clause 2 of INSS expressly provides that a person convicted by a session court has a right to appeal before the Honorable High Court. The legislature, in its wisdom, has recognized the importance of appellant review in safeguarding against the wrongful conviction. Your Lordship, as in the state of Rajasthan versus Kashiram 2006, the Honorable Court held that the appellant review is an essential safeguard against the wrongful conviction and judicial errors. Your Lordship, appellant jurisdiction is not merely a procedure but a substantive right guaranteed by law. In the present case, where gross miscarriage of justice has occurred, denial of appeal would amount to denial of injustice itself. Your Lordship, in the present case, the trial conducted in contravention of constitutional principles. Lordship, the appellant was deprived of fair trial and his fundamental right under Article 21 and 14 of the Constitution were blatantly violated. Your Lordship, a trial must be conducted in a manner that inspires confidence in the rule of law. If the due process of law is violated, the conviction becomes unconstitutional. Lordship, in the present case, the trial was conducted in absentia without affording the appellant's proper opportunity to defend himself, making this appeal maintainable. Your Lordship, every accused person is entitled to equal protection of law. Your Lordship, however, in the present case, the appellant was arbitrarily denied the safeguard ordinarily provided to accused. Your Lordship, in a democracy governed by rule of law, no individual can be treated unequally before the law. Lordship, the manner in which the appellant was convicted demonstrates that a clear violation of principle of fairness and justice make this appeal maintainable. Your Lordship, to conclude the first issue, in the present case, the trial court failed to order the procedural safeguard, wrongly applied the laws and violated fundamental rights. If this appeal is not maintainable, entertained, the innocent person may be unjustly punished, which goes against the very essence of criminal jurisprudence. Your Lordship, with your permission, may I proceed to issue number 2? Much obliged. Your Lordship, the second issue is, did the trial court in absentia adhere to due process? Your Lordship, a trial in absentia is an exception, not the rule. It is pretended only in defined circumstances and requires strict adherence to the procedural safeguards to ensure that accused is not deprived of his right of fair trial. Your Lordship, in the present case, the trial court produced an unlawful manner which makes the conviction unsuitable. Your Lordship, the legal system is based on the principle that an accused person has a right to present at his trial and defend himself. A trial in absentia can only be conducted in exceptional circumstances. Your Lordship, before declaring a person proclaimed offender, certain mandatory steps are followed and which are mentioned under section 84 of INSS. Lordship, it requires that a warrant must be issued and executed against the accused. Secondly, a proclaimed offender must be given at least 30 days of time period to appear. And thirdly, the proclaimed offender, the information about the proclamation must be published in the newspaper and the accused last known residence. And the third point was not uttered by the court, that the publication of the proclaimed offender notice was not there in the newspaper and the last known residence of the accused was not known to the court. Lordship, as in Sushil Kumar versus State of Haryana, 1988, the Supreme Court held that failure to follow the mandatory procedure for declaring someone a proclaimed offender renders a trial invalid. Your Lordship, the failure of the lower court to comply with the statutory requirements renders this trial in absentia unlawful and unconstitutional. Your Lordship, further, the trial did not satisfy the essential preconditions before the proceedings in absentia. The appellant court, not deliberately absconding and reasonable steps were not taken to ensure his presence before the trial. Therefore, the proceedings are legally defective. Your Lordship, a trial conducted in a manner that deprives the accused of his right to defend himself is unconstitutional, and the appellant was not given a fair opportunity to participate in the proceedings, making this conviction invalid in law. Lordship, section 340 and 341 of INSS mandates that an accused has the right to legal representation at every stage of trial. Your Lordship, even under international human rights, trial in absentia are considered exceptional, as Lordship, Article 14, Clause 3, Subclause D of International Covenant on Civil and Political Rights guarantee that every accused has a right to present at a trial and aims to defend himself personally or through legal representation. Lordship, also, Article 10 of Universal Declaration of Human Rights ensures that every accused is entitled to fair and public hearing by impartial tribunal. Your Lordship, the appellant conviction violates international legal principle, further providing that this trial was convicted unfairly. Lordship, a criminal conviction must be based on strict adherence of procedural laws. In the present case, the lower court failed to properly interpret and apply the provision of INSS 2023, resulting in miscarriage of justice. Your Lordship, to conclude, the lower court ignored procedural safeguards, making the conviction legally unsuitable. Your Lordship, as the interpretation itself states, as per the Salman had given the two laws, that is, firstly, literal rule, and secondly, logical rule for the interpretation. And Lordship, in this matter, the literal rule must be considered, that is, whatever the textual matter has been provided, that should be considered. Lordship, with your permission, may I
that I have a question.
Yes.
But you are claiming that the proper procedure was not followed.
Yes, Lordship.
But in your memorial it is mentioned that two notices, means two warrants were already issued.
Yes.
Under section 356.
Yes, Lordship.
Then what else are the other requirements?
Lordship, under section 84 of the INSS, there are three requirements. As per the third requirement is publication of proclaim offender news in newspaper, or where the last residence of the accused was there, in that area that notice must be published. So this was not performed by the court.
But is it mentioned?
In memorial. Lordship, under issue number 2, page 15, 2.2.
Page number?
Page number 15, 2.2.
Okay.
Lordship, the issue number 3 is, was the lower court application of substantive and procedure law appropriate? Lordship, the counsel for the appellant most respectfully submits that trial court has grave delayed its application of substantive and procedure laws, resulting in miscarriage of justice. Lordship, the appellant's conviction is based on incorrect application of legal provisions and procedure irregularities. Your Lordship, the appellant conviction under section 63 of INS 2023 is legally unsuitable, as it is based on incorrect interpretation of rape on the false promise of marriage. The prosecution has failed to prove the appellant fraudulently induced the complainant into sexual intercourse. Your Lordship, In Pramod Subramaniam Pawar versus State of Maharashtra 2019, the Supreme Court held that false promise of marriage amounts to rape only if the promise was made with fraudulent intent from the beginning. Your Lordship, in the present case, the prosecution failed to prove that appellant time of obtaining consent. Therefore, the conviction is legally unsuitable. Your Lordship, the appellant and the complainant were cohabiting in a living relationship and they had even purchased a house together which they shared. The complainant actively contributed to the relationship and was financially involved. Lordship, a long-term living relationship negates the case of inducement as both parties were equally responsible for their decision. Lordship, the appellant promise was genuine and he made concerned financial commitment such as saving of money for the wedding. Lordship, the promise was withdrawn only due to external pressure from the appellant's family, which did not amount to deceptions. Importantly, after withdrawing from the marriage, the appellant did not engage into any further sexual intercourse. This clearly shows that there was no ongoing fraud or inducement. Your Lordship, the complainant entered into relationship voluntarily, fully aware of the uncertainties involved. The principle of voluntary non-fit injuria applies here. Lordship, as one who voluntarily undertakes a risk cannot let a claim of the damages from it. Your Lordship, in addition, a person cannot take advantage of their own wrong. The complainant monitored the appellant's social media account with consent, accused his personal financial information, and acted unreasonably leading to conflicts. Your Lordship, Section 52 and Section 184 of INSS 2023 mandates medical examination of accused in the case of sexual assault. However, in the present case, no such examination was conducted. Lordship, the absence of medical report creates serious doubt about the prosecution case and further weakens the charges of Section 63 of INS 2023. Your Lordship, in CBI versus Anupam Kulkarni,
You are taking two defense together. One place you are saying that there was a consent, another you are challenging the medical, you are expecting the medical examination should have been made. How things can come together?
Lordship, firstly, as they were having the sexual intercourse, but if it is forceful or if it was
So it is not the case of a prosecution that it was
Yes.
forceful.
Yes.
It is not the case.
but Lordship, certain medical requirements are there.
Are you challenging? Is it your case that there was no sexual relationship between you and the leader?
No, Lordship.
No, it is not your case. You are saying that there was a consent. Then the question comes to medical examination.
Your Lordship, when the accused was given the remand, firstly they must at least check whether the sexual intercourse was considered a time period or at how much interval of time that was being between them. Time period to detect that it was before how many months or the time past.
You must give that period. You must give that period. When you are in a relationship, you have the
Yes, Lordship.
before that there was a relationship. After that, have you restrained yourself in taking up the relationship?
No, Lordship. Yeah.
So you haven't had the defense. You haven't examined yourself or any other witnesses where you can prove that yes, before proposal there was a relationship, but when we have restrained ourselves or when our relations got sustained, after that we haven't kept any kind of a relation. So this shows you are deceitful or your default from your part.
Okay, Lordship.
What answer you have for that? Because you are arguing both the points.
Lordship, as here it is stated that after there was dispute between them, there was no sexual relationship between both of them.
So you are admitting.
But after the disputes were arising to them or the marriage was rejected, promise was rejected. After that, there was no sexual relationship that we are stating here.
So after that some act has been done by you. You have withdrawn the money. You have transferred those money to third person.
Third person.
Not in her account.
Yes, Lordship. But here the question does not arise of the rape has been committed or the sexual intercourse has been committed after that time period. That's it, Lordship.
How the principle of voluntary non-injuria will apply to the cases of criminal prosecution. This principle is carved out under the tortious liability.
Yes, Lordship.
So once your case is not tortious case under tort, and that principle is related to the tortious cases, how that will apply to the criminal law?
Lordship, just we want to say that the one who voluntarily undertake the risk cannot later claim the damages to justify the statement he had used the legal magazine.
Yes.
Lordship, further, the continued extension of police remand beyond legal limits violates fundamental rights and renders the trial unfair. Your Lordship, the appellant was subject to several custodial torture, leading to an involuntary confession. This is direct violation of right against the self-incrimination under Article 20 Clause 3 of the Constitution. Your Lordship, Section 22 of ISA states that prohibits the use of confession obtained through coercion, inducement or threats. Your Lordship, the appellant was declared a proclaimed offender without following the mandatory procedure. So here it lacks the procedural followings. Lordship, further, in Sushil Kumar versus State of Haryana, the Supreme Court held that failure to follow the mandatory procedure for dealing someone a proclaimed offender renders the trial invalid. Your Lordship, also in Maneka Gandhi versus Union of India, the Supreme Court has held that right to life and personal liberty cannot be curtailed except through just, fair and reasonable procedure. Your Lordship, the repeated police remand and coerced conviction amounts to clear violation of Article 21, making the conviction unconstitutional. Your Lordship, to conclude the third issue, if the principle of equality and fairness are not upheld, the entire justice system will undermine through the conviction that should be set aside. But should be like your Lordship. Lordship, the further issues will be dealt with my own counsel. Thank you, Lordship.
Lordship, with your permission, may I proceed to the issue number 4? Lordship, fourth issue is, was the charge of rape correctly applied? Lordship, counsel of the appellant must respectfully submit that the charge of rape has been wrongly applied in the present case. The prosecution has failed to establish that the alleged sexual relationship was based on deception or coercion. The relationship between the appellant and the complainant was consensual, and the failure to marry was due to circumstances beyond the appellant control rather than the fraudulent intent. Your Lordship, the new law INSS and ISA came into effect on 1st July 2024. However, the charge sheet and conviction were based on outdated laws, making the entire process unlawful. Lordship, FIR was lodged on 1st August 2024, meaning the new law should have been applied. But the prosecution wrongly filed the charge sheet under the old law, that is Section 376 of IPC, and the punishment was also awarded under the outdated provisions. Your Lordship, in criminal law, it is well established a principle that mere breach of a promise to marry does not amount to rape unless there was fraudulent intent at the outset. Your Lordship, the relation between the appellant and the complainant was based on mutual affection and the voluntary participation. The complainant and the appellant were in a romantic relationship for several months, during which they willingly engaged in physical intimacy. Lordship, Section 63 INS 2023 defines rape as sexual intercourse without valid consent. However, when two consenting adults willingly engage in a relationship, it does not fall without the definition of rape. Your Lordship, in the present case, the complainant entered into the relationship with full knowledge and voluntary consent. Therefore, the charge of rape is legally untenable. Your Lordship, as a case of Anurag Soni versus State of Chandigarh 2019, for a false promise of marriage amount to rape, the prosecution must establish first that the promise to marry was false from the beginning. Second, that the accused never intended to fulfill the promise and it was solely to obtain the consent for intercourse. The appellant and the complainant were in a long-term relationship and there is no evidence to show the appellant and dishonest intent from the beginning. Lordship, in Pramod Pawar vs. State of Maharashtra 2019, the Honorable Supreme Court held that a breach of promise to marry does not amount to rape unless the prosecution can establish that the promise was false at the time it was made and the accused has fraudulent intent from very beginning. Your Lordship, the fact of this case do not meet this legal standard and therefore the charge of rape must fail. To conclude, Your Lordship, the prosecution has failed to produce any independent evidence proving that the appellant made a false promise of marriage with fraudulent intent and the complaint concern was obtained through misrepresentation and there was a forced portion under influence of the complainant. If the absence of such proof, the conviction is legally unsustainable. Much obliged.
You conclude yourself in 1 minute.
Conclude your prayers.
Your Lordship, with your permission, may I submit the prayer? Much obliged. Wherefore, the light of the facts, issue raised and the argument advanced, the appellant most humbly prays before the High Honorable Court to first set aside the conviction of the appellant under section 376 of Industrial न्याय Sanhita 2023 and declare the tire absentia as unconstitutional and violate of due process. Second, hold the repeated extension of police remand was unlawful, arbitrary and violation of section 187 clause 2 of INSS 2023. Third, hold the charge of rape was wrongly applied or grant any other relief of this honorable court effective, just, equitable and necessary in the interest of justice. And for this act of kindness, the appellant and his duty bound shall ever pay. Much obliged, your Lordship.
Yes, please.
Now I request the respondent team 18.
Team number 18.
Greetings to your bench, your lordships. The council is representing the respondents in the case of Rochesh versus State of Arevo.
Your speaker number 1 or 2?
Speaker number 1, your ladyship. Your ladyship, the council would like to collectively address the bench as your lordships. Much obliged. Lordships, the council would like to repeat that the laws in the state of Indus-land are in parliamentary with India. Much obliged. Your lordships, the councils for the petition, the appellant has approached this honorable court by invoking the jurisdiction in this matter under section 415 subsection 2 of the Indus-land Nagarik Suraksha Sanhita, which provides the person convicted in the trial by a sessions court to approach the Supreme Court when there is imprisonment for more than 7 years or up to life imprisonment. The council seeks permission to proceed with the issues, Your Honor. Your Lordships, we have 5 issues to be dealt with. The first 3 issues will be handled by me as the council number 1, and the last 2 issues will be dealt with my co-counsel. Much obliged. Due to the scarcity of time, the council would like to proceed with the arguments at once, Your Honor. Much. Your Lordships, the first issue in hand is related to whether the appeal is maintainable in this High Court or not. The council acknowledge and we do believe that the appellants have the right to approach the higher court in case of their conviction, but we would also humbly request this Honorable High Court to summarily dismiss this case because there is no grounds, merits or substance in this case, Your Lordships. Because, Your Lordships, they have contended that the petitioner, the appellant's rights are violated, their natural justice principle was violated. Your Lordship, the council would like to put in light the fact that the provision of section 356 of INSS was incorporated in this particular newly created law, which is INSS, because the legislators understood that a handful of fugitive offenders who are committed or convicted under heinous crimes, they evade trial, they abscond themselves, they hamper the proceedings of the criminal justice system, which hampers adversely the timely delivery of justice, Your Lordship. And the same was contended by Justice Dr. Ayushman in Abhishek versus the State of Bihar, where the Honorable Judge has expressed his concern towards the willful absenteeism by the fugitive offenders in case of heinous crimes, Your Lordship. So, since there is no merit and the Honorable Justice of the Sessions Court had taken into consideration all the facts and circumstances and had complied with the procedures that are put forth in the in this land Nagarik Suraksha Sanhita, and the appellant was rightly charged under section 375 read with section 90 of IPC for the offence of rape, Your Lordship. So the council's for the respondent would humbly like to submit that this appeal should be summarily dismissed. If Your Lordship would permit, the council would like to proceed with issue number 2, Your Lordship. Much obliged. Your Lordship, the issue number 2 in hand is with respect to whether the trial that took place in the absentia of the appellant in this case was violative of due process or not. The council would like to humbly submit that there was no violation of due process, as the trial took place in compliance with the procedures established under section 356 of INSS. The council has already mentioned the legislative intent behind inserting this particular section, which was absent in the colonial law, which is CRPC, Your Lordship. Because the legislatures have noticed, and there was a lot of concerns raised by numerous judges in various cases related to the willful absenteeism that the fugitive offenders are creating, because they are in the manifestation that the criminal judicial system will be in halt if they do not appear in front of the court or they are not arrested, Your Lordship. Your Lordship, in section 356 of INSS not only empowers but also mandates the judge to move forward with the trial and even pronounce the judgment in case if a proclaimed offender is willfully absconding himself or evading trial and fails to adhere to his duty, that is to appear before the court, Your Lordship. The council would also like to reinforce that the appellant here was on bail. The charges were not dismissed. He was sent on bail. So he definitely had a duty to appear in front of the court whenever he was called for. And the principle of audio ad partem says that no man shall be condemned without being given a fair opportunity to be heard, Your Lordship. Opportunities were given not once, twice, but multiple times. He was given summons and then the warrants were sent, which the police were not able to execute just because the appellant was nowhere to be found, and then he was absconding himself, Your Lordship. He was in the presumption that the entire judicial proceedings will be into halt, and the life of the judicial process is completely dependent on his willingness to either appear in front of the court or not, Your Lordship. When the statutory provision in itself is providing that, providing either specifically or by necessary implication to exclude principle of natural justice, when procedures are established how to proceed with it, the council believed that here the judicial magistrate of the Sessions Court had acted with prudence and he had taken necessary care, and justice was done when this right of the petitioner appellant was hampered here, Your Lordship. And Your Lordships, the council would also like to reiterate that the principle of audio ad partem is not a straight jacket principle. Depending upon the nature and also the proceedings that are happening here, it should be noted that the appellant here is a proclaimed offender. He was absconding himself, he was charged for a heinous crime, and where the punishment cannot be less than 10 years but could also extend to life imprisonment. The fact should be noted, Your Lordship. Your Lordship, if the bench is satisfied, the council will proceed with issue number 3.
It is okay that appeal was maintainable. You have admitted that the appeal is maintainable. So we have to presume that the condition under subsection 7 is complied with. So we will believe that the accused is present before this court. Accused is present before this court while filing this
Yes,
appeal.
Your Lordship. Yes.
So a person who was proclaimed offender,
Yes.
convicted for life imprisonment,
Yes.
why he will return to the court again for filing appeal if he has intention to flee away from the justice? And he has done that in according to you by, and therefore court was required to issue the proclamation. Then why he will surrender before the court for taking punishment?
Your Lordship,
So why we should not infer that the proper procedure was not followed under section 359? Otherwise he would have having an opportunity to come before the court and address his case.
indeed, Your Lordship, the council believes that the accused in this case had played very well with the criminal justice system, Your Lordship. He failed to appear in front of the judicial magistrate. He even failed to appear in front of the sessions court.
Where is question of appearing before magistrate when case was purely triable by session judge and magistrate has only role to commit the case before the session judge?
Yes, Your Lordship. Then the summons were also issued by the judicial magistrate, which is given in the facts. Because he was on bail before the case was committed to the sessions court, he was given summons via judicial magistrate.
What about the publication in newspaper? Then what about the publication of proclamation in newspaper?
Your Lordship, in the facts it is clearly mentioned that all the procedures under INSS were followed by the judicial magistrate before declaring him to be a proclaimed offender.
How magistrate can declare proclamation under INSS?
Your Lordship, we have series of...
Because we have procedure under section 82 of CRPC also. Why not section 82, section 82 of CRPC was applied?
Your Lordship, because in this case, the filing of FIR to every proceedings that took place after the commencement or the enforcement of the law. So the section 531 of INSS, the repeal and saving section clearly talks about when there is trial proceedings that are that took place before the enforcement of the law can proceed with CRPC. But in this case, all of the procedural aspects starting from the filing of FIR to remand to the committing of the case to sessions court, everything took place after the enforcement of the new laws. So the court was right in carrying on its proceedings as per INSS, and we also protected the right of the accused under Article 20 Clause 1 by not following the ex post facto laws because he was tried and convicted under Section 375 of IPC. He was not convicted under new laws, which is Nagari INS.
You may proceed.
Yes. Lordship, my co-counsel will take up things.
Council seeks permission to proceed with issue 4 and 5. Your Lordships, this is to submit that the appellant has been rightly charged under the offence of section 375 read with section 90 of the IPC and is guilty of the same. Your Lordships, the actions of the appellant since the beginning, they show no intent of him to marry the prosecutress. In fact, they were made in the bad faith. Your Lordship, since we are dealing with a case of rape because by false promise, it is important to read section 375 along with section 90. Your Lordship, section 90 does not define consent per se, but it also says that what is not consent. According to section 90, Your Lordship, consent is not a consent when it is given by a person because of fear or injury or under misconception of fact, as both of these vitiate the consent given by the individual. Your Lordship, in this case, we would take the misconception of fact in this case. Your Lordships, just because in Pramod Suryaban Pawar versus State of Maharashtra, the court has said that to establish a consent that is vitiated, two propositions must be established. One is that the promise of marriage must be a false promise given in a bad faith with no intention to comply with it, and the second is the false promise must itself be of immediate relevance or bear nexus with the woman's decision. The Lordship, as held in Anurag Soni, it would be right to say that the consent given by the prosecutrix on the conception of the fact arising from a false promise of marriage cannot be said as a consent under the eyes of law. Your Lordships, let me take you through how this promise was a false promise, Your Lordship. Your Lordship, first and foremost, the promise made by the accused shall be considered as a false promise, since the Apex Code has time and again distinguished between false promise as well as breach of promise. The former is that when a promise is made at the inception itself, it is made in a bad faith and there is no intention of complying with it. And the latter is that the promise that is made is made in a good faith, and due to some circumstances it is impossible to fulfill it. Your Lordships, the case in hand falls under a false promise and not breach of promise. All the facts that are pointing towards a false promise. It is very evident that the accused never had the intent of marrying the prosecutrix. There is no present substantial fact that shows that the promise made by the accused to marry the prosecutrix was impossible to fulfill, Your Lordship. Your Lordships, I would like to walk you through the events which could conclude that these are false promises. Your Lordship, starting from the accused who himself expressed his intent to marry the prosecutrix, and later he started saving money also to make her believe that he is fully committed to his promise of marrying her. And later, as falling to her prey as he wished to, the prosecutors also significantly started giving money for the savings of their marriage, impending marriage allegation. Later, the accused withdrew the savings money without her knowledge or consent, Your Lordships, which she got to know not by him also. And while being questioned upon, the accused gave us reason that to cover the losses incurred by his startup business, and the money which was taken was put in the joint account with another woman whom later he was supposed to marry also. Additionally, Your Lordships, the accused and the prosecutrix jointly purchased a house in the name of the accused. That later again he sold without the consent or the knowledge of the prosecutrix. And then again the proceeds of the sale of the house were sent to the same account with another woman which he was about to marry. And later, if the learned opponents want to say that because of the external pressures of the family, Your Lordships, not even in one instance he stood up for his own relationship. He is a 32-year-old man with a successful startup business. If he can be so independent in starting up his business, he can be independent to also stand up for his marriage or relationship. Your Lordships, the false promise has a direct nexus with the prosecutrix consent, Your Lordships. That they were in a relationship for a very long time. But upon trusting the accused appellants promise to marry by the end of the next year, that is 2024, at that time only she agreed to get into a sexual relationship. Your Lordships, the accused has deployed marriage as a tool for her to again and again convince and put her in the veil of distortion that he is totally committed towards their relationship and the marriage.
How you describe the live-in relationship? How you describe the live-in relationship? You said that when he proposed, at that time only you indulge into the sexual relationship. So before that, it is agreed that you have just argued that you both were resided in live-in relationship. So how you describe the live-in relationship? I mean, in living relationship, whether there was no sexual intercourse or there was no sexual relationship between you?
No, Your Lordship.
Then how you named that in live-in relationship?
Your Lordships, there are no such facts indicating that there was, if it was a case that she was getting into a relationship, there wouldn't have been a thing that on only after December 1st of 2023, she agreed to a sexual relationship, and that too she agreed to it. She never initiated it. That is a different case, your ladyship. But still, it is a matter that after him, again and again, after his one last promise that they would marry and believing their impending marriage, she got into a sexual relationship before that.
You are saying that he's a 32 years old man. How old you are? You're not a 15 or 16 years girl.
Your ladyship,
You also
I
have
am
your
30
own.
years old.
Huh.
I am 30 years old, your ladyship. And that is
you
why,
are quite
being a
competent.
30-year-old woman, I know what are the consequences of getting into a sexual relationship, and
Yeah.
I never got into a sexual relationship.
So the full
before that.
consent was there. Your full consent was there. Your full support was there. How you justify section 375 in which he has been convicted?
Your lordships, my consent
The
was
consent was not obtained by any forceful, or your full consent was there. The consent was valid.
Your lordships, the consent was because of the misconception of the facts. The consent cannot be, the charges of rape cannot be vitiated just because there was a consent, your lordships. The lordships, the consent was because there was a misconception of facts since the beginning by the accused. He had been trying to put her into a vicious circle, and later only. The lordships, it is to be noted that the prosecutrix agreed to the sexual relationship after a long time. After him proposing that he shall marry by the end of 2024. Yes, Your Lord.
How you can ride on two horses? How you can ride on the two horses at the same time?
Your Lordship,
At one hand you are alleging offense of rape. At another hand you are alleging offense of domestic violence. If you are accepting domestic violence complaint, then you are accepting the physical relations by consent only.
Your Lordships, all
Because as far as allegations are concerned, complaint was filed for domestic violence also. That was not proceeded further. There are allegations of cheating also. You have not raised appeal against the non-prosecution under section 420. Only you are defending the appeal filed by the accused. So if your original case is of rape as well as domestic violence, how both can run concurrently?
Your Lordship, in the fact it is said that he slapped her while getting into a conversation.
Slapping her may be offense under 323 of IPC. How 375 then?
Your Lordship, sorry, slapping.
You said that after slapping only entire episode has started.
Your Lordship, this case is after the filing of charge, Your Lordship. The police after the investigation and the judicial magistrate after the investigation, this is after the filing of charge sheet, Your Lordship. There was an investigation and the Sessions Court found it right to put this case under 375, Your Lordships. That is why they are coming for the appeal against 375. And we are defending that, Your Lordships.
So as far
Sir,
as allegations of domestic violence
Yes, Your Lordship.
and cheating, you don't have any words.
Your Lordship,
You don't want to say anything about that.
he has again and again, he has cheated, Your Lordship, by taking all the money out without her consent or
Then
any
why
knowledge
not?
of
Why prosecution has not proceeded for 420 also? Why only 375?
Your Lordship's
Because your original complaint is for 420 also. Allegations are that he has withdrawn the amount which was received from complainant. He has siphoned that
there was
amount to
no
the account
such,
of Maya.
there was no such FIR on base of cheating, Your Lordships.
She has given complaint. FIR has to be written by the police officer. And investigation has to be by the police officer. Then why prosecution has not raised this issue before the trial court?
Your Lordship, we are defending the final charge.
So therefore I am asking you, you are defending the judgment which is converted into conviction of a man and he was sentenced to suffer life imprisonment. In such circumstances you should answer this. Just defending the judgment of trial court is not your job. You have to satisfy that in what circumstances you are lieu of section 420, why there was no prosecution under Domestic Violence Act. If there is complaint of Domestic Violence Act, then she is admitting that she was in live-in relations with accused. Then there is no question of rape.
Your Lordships, the sexual intercourse
Misconception will go in accepting the complaint under domestic violence.
Your Lordship, we are against the, Your Lordship, this is a moot court competition and not a national trial advocacy, Your Lordships. I apologize for speaking in that way if you feel, if I'm being offended or if offensive. But Your Lordships, we as the defendants are here for the appeal filed by the appellants against the charge of rape. And that is why we will
And
be
therefore,
with
therefore I put a question that once case is of domestic violence along with allegations of rape, and once you are accepting that there was domestic violence, you are accepting live-in relations also. So once you are accepting live-in relations, then your relations, physical relations with consent only.
Your Lordship, the consent, as in the memo also, it is said that it is not a proper consent. As per section 90, it is given that misconception of fact cannot be called as a consent.
Then why allegations under domestic violence?
Your Lordship, it was prior, Your Lordship.
Because
After the investigation, the final charge sheet was
Law
under
is developed
375.
much. Law says that if you have relations, you are in live-in relations, provisions under Domestic Violence Act will apply. And once those provisions are applicable,
Live-in relationship per se will not be there applicable, because live-in relationship, there is one thing that the society must also believe.
the complaint,
These are your
they have purchased the house, they were residing together. That is what the complaint is.
Yes, Your Lordship.
So what kind of relations those were?
But they were having a very professional bond in
That is
front of the
outside.
society.
That is outside the house. They were professional. As far as inside the house, they were residing together.
Your Lordship, as per my knowledge, what I have read about live-in relationship is that one of the criteria is that the society must agree that they were in a live-in relationship. But in front of the society, Your Lordships, they were having a very professional bond, and there was no such thing that they were having a personal bond. So in that case, I don't think, Your Lordships, live-in relationship per se would be applicable here. So, with your permission, if I could proceed with issue 5 or
No, continue.
Come to prayers.
Thank you. In the light of the facts of the case, issues raised, arguments advanced and the authorities cited, the counsels on behalf of the respondent humbly pray before the Honorable High Court of Aryapur to kindly adjudge and declare that this appeal is not maintainable before this High Court, that the trial in absentia does not adhere to the due process, that the lower court's application of the substantive and procedural laws is appropriate, that the charge of the rape is correctly applied, and that the repeated extensions of the police remand is lawfully considered and with constitutional protections, and or pass any order which the bench deems fit in the best interest of the justice, equity and good conscience, and for this act of kindness the counsel on behalf of the respondent as in duty bound shall forever pray. All of which is respectfully submitted.
So you are in moot court. In future, court will not bear you. You have to be ready in all of this.
Your Lordships, we are learning, and with your insights we will learn more. Your Lordship.
You really have taken good submissions. Good. Thank you.
Hello. 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 Hello.
किती नंबर आहे आता? या या माईक व्यवस्थित चालतं. माईक ॲज वेल एज माईक.
त्यांनी दोनच दिल्यात का? राईट ओके नो प्रॉब्लेम. टीम नंबर कुठल्या टीमने दिला? Appellant.
Now I request the appellant, team 16, to come forward and proceed their arguments.
टीम
Team 16.
16.
1-6.
1-6 and that side 11.
11.
Appellant 1.
1.
May it please your lordship, this is student council appearing on the behalf of appellant in the case of Rajesh versus the state of Rajesh versus the case of state of Ayapur. Your lordship, if with your permission, may I state the fact of the case. Your lordship, the appellant Rajesh was in a romantic relation with Ria and they started living together. Rajesh proposed to Ria promising marriage by the end of 2024. And Ria agreed to sexual relationship but believing in the impending marriage. Rajesh, a 32-year-old entrepreneur, was falsely accused by ex-partner Ria of rape, domestic violence and exploitation. Despite the consensual relationship, Ria lodged an FIR against Rajesh after he ended their relationship. The police arrested Rajesh, tortured him and forced him to confess. However, Ria's allegation of rape, domestic violence and exploitation under false pretense are disputed. The appellant claims that the sexual relationship was consensual and Ria's accusations are baseless. The appellant also alleges that the police investigation was flawed and he was tortured and forced into confessing. The remand proceedings were also mishandled and the appellant was granted default bail after 90 days period in the police custody. The trial was conducted in absentia. Rajesh was sentenced to life imprisonment under section 376 and appellant's conviction under section 376 of the English Land Penal Code is being challenged. The appellant's affidavit has preferred an appeal before High Court challenging the trial, the handling of the remand proceedings and conviction. If your lordship are well versed with the fact, may I narrate the issue of the case. Your lordship, there are 5 issues in this case, in which the first 2 issues will be argued by me and the remaining 3 issues will be argued by my counsel. Your lordship, the first issue is the appeal maintainable before the court, before the Honorable High Court. Your lordship, my contention regarding to this issue is the appeal is maintainable before the Honorable High Court. The right to appeal is a statutory right and it secures the concept of fair trial. Right to appeal is a statutory right and the person who cannot appeal against an order unless it is provided by law. Lordship, I would like to refer the judgment in the case of Dilip Damirkar versus the Kotak Mahindra Company Limited, in which the Honorable Supreme Court held that an appeal is an indisputably statutory right and an offender who has been convicted is entitled to avail the right to appeal. The Lordship, as a part of a concept of fair trial, in Article 21, the Supreme Court has explained that one right to appeal from Session Court to High Court is essential where the criminal conviction is brought about with a long loss of liberty. The Lordship, the right to appeal against some conviction is a statutory right and it is provided under Bharatiya Nagrik Suraksha Sanhita. The Lordship, the right to appeal against some conviction is a statutory right and it is provided under section 415 of the Bharatiya Nagrik Suraksha Samhita, and it is also provided under Article 21 of the Constitution. The Lordship, as per Section 415, Clause 2, Bharatiya Nagrik Suraksha Samhita, any person convicted on a trial held by session judge, additional session judge, or on a trial held by any other court in which the sentence of imprisonment more than 7 years has been passed against him or against any person convicted at the same trial may appeal to the High Court. Your Lordship, I would like to refer the judgment in the case of Motiram versus State of Madhya Pradesh, in which the Honorable Court held that every convict sentenced to life imprisonment has right to file appeal against before the High Court. Your Lordship, in the instant case, the petitioner has been sentenced for an life imprisonment by the session court. He has right to appeal to the High Court in order to review the decision given by the session court and correct errors and perversity. And hence the present appeal is unmaintainable as it clearly statutory right given to person aggrieved by the decision of a lower court. Your Lordship, that appeal can be presented even through his advocate. Section 423 of the BNSS says every appeal shall be made in the form of petition in writing presented by appellants or his advocate. Every such appeal petition shall be accompanied by a copy of judgment or order appealed against. Your Lordship, Section 423 gives right appellant to present his appeal either through himself or with his advocate. The earlier code also contained the same provision, thus it is a statutory right of appellant to present appeal through his advocate. In the instant petition, the appellant has present his appeal through his advocate and hence it is maintainable. If the Honorable Court is satisfied with my argument, I would like to proceed my next argument. Lordship, the second issue is that did the trial in absentia adhere to due process? Lordship, my contention regarding to this issue is the trial in absentia does not adhere to due process. Lordship, audio alternate pardon is a rule of natural justice which says that no one should be condemned unheard. The trial should be conducted in the presence of accused, and in the instant case the accused is condemned unheard. Lordship, the defendant must have a chance to present their case and they defend themselves as a defendant has right to legal representation. Without defendant presence, there is a higher risk of wrongful conviction. Lordship, the trial in absentia does not adhere to due process. According to Article 21, no person shall be deprived of life and liberty, personal liberty, except according to the procedure established by law. Right to fair trial includes the trial should be conducted in the presence of the accused, and it is one of the facets of the Article 21. Your Lordship, I would like to refer the judgment in the case of Maniga Gandhi versus Union of India, in which the Supreme Court widened up the scope of Article 21 of the Indian Constitution by stating that due process is a procedure established by law. Lordship, the trial in absentia was not carried out according to the procedure given by the Bharatiya Nagrik Suraksha Samhita. Section 356 of the Bharatiya Nagrik Suraksha Samhita mandates the court to proceed with the trial in the absentia when a person declared as a proclaimed offender has absconded to wait trial and there is no immediate prospect of arresting him. It also specifies a mandatory waiting period of 90 days. Lordship, from the date of framing charge before commencing the trial, and in the instant case the session court has not followed the procedure as 90 days has not lapsed from the date of framing charge, not giving the petitioner fair opportunity to prepare the defense. Lordship, whereas subsection 2 of the section 356 talks about the procedure which has not been complied, but there in the present case the time interval between the two consecutive warrants is 28 days and the provision clearly specified the period of 30 days. Along with that, there is no information public regarding to the petitioner being proclaimed offender and in any local or any newspaper requiring him to appear before the court for trial. Meanwhile, the Section 84 of BNSS also requires court to publish written proclamation requiring the accused to appear at the specific place and a specific time. Your Lordship, hence the court has failed to follow the many provided procedure related to conducting trial in absentia, making it unfair to the petitioner and not adhering to due process. If the court is well satisfied with my arguments,
How you justify that now just now you have argued that you have not been given an opportunity to appear. You were there in the custody, you were knowing that some or the other day the charge sheet would be filed. You were keeping the eye because you were knowing that the summons has been issued, that the warrant has also been issued. You waited that the proclamation order would be pass, how will justify these things? How you can say that the procedure is not been filed?
Your Lordship, there is a period of 90 days where the proclamation was issued and the charge sheet was filed in the end of November, and the date of consuming the court, conducting the court was not complete the period of 90 days. So they have failed in the period of 90 days.
You wanted that all procedures should be followed.
They also
You do not want to follow your own duty. Was not your duty to come before court when very first time summons has been issued?
Your Lordship, there is we are accepting that the summons was issued and the warrant also was issued, but there is a procedure which would not be followed by the learned trial court.
What procedure you have filed?
There is a period of 30 days of issuance of warrant, and they does not fulfill that.
Can you take benefits of your own wrong?
No, Your Lordship, the fact sheet does not provide the commencing date of the trial. So the fact sheet itself says that it was silent, so we cannot consider any period of 90 days.
Please.
I would like to call my co-counsel for the further issue.
Much obliged, Your Lordship. May Your Lordship permission, may I proceed with the remaining three issues. The third issue involved in the case is, was the lower court application of substantive and procedure law was appropriate? My contention regarding this issue is, the lower court application of substantive and procedure law was not appropriate. The learned trial code or in applying the BNS to the present case instead of IPC, the BNS shall be applied to the case if the alleged act is committed after 1st July 2024. That is, coming in the force of BNS, Bharatiya Nyaya Sanhita, to the offence committed before the said date, IPC would apply. Now looking at the chronology of the event, on the 1st December 2023, Rajesh proposed Riya, promising marriage by the end of 2024. Trusting his commitment, Riya agreed for a sexual relationship, believing in their impending marriage. During the business trip to the Naga city in the end of July, after discussing about the wedding in the hotel room where they stayed together, Rajesh decided to end their relationship. Thus, the alleged offence was committed in the series of acts extending up to the end of July 2024. Thus, the offence was committed in the end of July 2024, and hence BNS was the law which should be applied to learned trial court. The learned trial court erred in applying the various provisions of the BNSS incorrectly, like section 173, 187 and 356 of BNS. The learned trial court did not apply the procedure established in section 173 properly. That as per the section 173, preliminary inquiry is to be conducted only if the offence is punishable with 3 to 7 years of punishment. But the alleged act in the instant case comes under section 69 of BNS or section 375 of IPC. For both, the punishment is more than 7 years. So, hence the procedure law was not applied properly. The initial inquiry was conducted by the police. The learned trial court did not apply the procedure established in section 187 properly. As section 187 clearly says, the maximum number of the days for which the police custody is 15 days, which may be taken into parts or whole, be granted within the first 60 days or 40 days. Here in the case, total period of police custody granted was up to 90 days, which clearly violated the procedure established under section 187. The learned trial court did not apply the procedure established in section 356 correctly. Under section 356 of BNSS, it specifies a mandatory waiting period of 90 days from framing of the charge. In the instant case, the session court has not followed the procedure, and subsection 2 of the section 356 BNSS says that the 2 consecutive warrants should be issued between the interval of 30 days. But in the instant case, the first warrant was issued on 1st December and second warrant was issued on 28th December, which does not comply with the provision. Hence,
the session court has failed to follow the many provided procedure related to conducting trial in absentia, making it unfair to petitioner and not adhere to the due process. If the lordship is satisfied with my submission, the council seeks permission to proceed with the next issue.
There is no date of conviction.
There is
No date of conviction.
no sir. There is no date of conviction.
Correct. Date of committal is there.
Yes, sir.
After date of committal,
Yes,
how you can say that court has not waited for 90 days?
sir.
After committal only there will be framing of charge.
Yeah.
Magistrate has no power to frame the charge when case is triable by session court.
Yes, sir.
Charge must have been framed by the session judge only. That is after committal. So committal date is there. Judgment date is not there. So under what pretext or under what circumstances you can say that there was no 90 days period?
As the fact sheet says that the charge sheet has been filed in the end of November, and taking into considering that the charge was framed after the charge sheet has been filed.
Yes.
So, and the fact sheet in point number 22 says that the subsequently in February 2025 the case was committed.
Committal.
And section 3
Committal comes before the framing of charge,
Yes,
not
sir.
after framing of charge.
Sir, the section 356 of BNSS says that subsection 2 एक मिनट section 356 provided that the court shall not commence the trial. Commence means the trial should not commence unless the period of 90 days has lapsed from the date of framing charge.
So from where you get that court has not followed that 90 days period when matter was committed to the sessions court in February 25.
Sir, the procedure was started in February. So the provision says that the trial should not be commence the trial, and trials has been started in February. That's why we are taking, and the fact sheet is silent about the specific dates, so we can't consider the dates. That's why.
We can consider. You
Yes,
are
sir.
before this court on this 22nd
Yes.
22nd March. Conviction is within 1 month. Conviction is in 1 month.
Conviction.
Even only after conviction you are here.
Yes, sir.
So this conviction must be before today.
Before July. Okay.
So you can say that 90 days are not followed.
No, sir.
Okay. Proceed.
Next point.
With the lordship's permission, may I proceed with the next issue?
Yes.
The next issue involved in the case is, was the charge of rape correctly applied? My contention regarding to this issue is that the rape charge are not properly applied in the present case. That learned trial court ought to have charged accused under section 69 of BNS as the alleged offence was committed in series of acts extending up to 8th of July 2024. Thus, the offence was committed in July 2024. Hence, the Bharatiya Nyaya Sahita was the law to be applied to the by the learned trial court. The term offence means an act of omission made punishable under the act. According to the section, the word act denotes a single act as well as a series of acts, or the word omission denotes a single omission as well as a series of omission. This clearly states that the alleged act was committed from 1st December to the end of July. So taking into consideration the fresh act, the BNS should be the law which should be applied by the learned trial court. My second submission regarding to this issue is that the accused cannot be charged under section 375 of the IPC. The learned session code is wrong holding the accused liable under section 375 of Indus-Land Penal Code, that the accused had not done the act which constituted an offence of rape as given under section 375. There was a consensual sexual relationship between the two. There was a breach of promise, not the false promise, given by the petition appellant. There are 7 different descriptions given under section 375 which explain non-consensual consensual intercourse, which means if man had committed a sexual relation intercourse with a woman and his act falls under any of the given description, he had been convicted an offence of rape. In the instant case, the act done by the appellant does not constitute an offence of rape, as the appellant had done the said act after obtaining free consent from the defendant, from the victim. That in the instant case there is consensual sexual relationship between the two, and that the act of the accused does not constitute an offence of rape. The accused does not hold any malified intention for the complainant, and the consent given by the complainant was free. I would like to cite a case. In the case of Deepak Gulati versus State of Haryana, the court has observed, with your lordship's permission, come to prayer. Prayer. Okay. Prayer. Wherefore, in the light of the stated fact, issue raised and argument advanced, authorities cited, submission made herefore above, those to be heard at the time of hearing, the appellant most humbly and respectfully prays before the Honorable High Court to please quash and set aside order of the Honorable Session Court convicting the accused for offence under section 376 and thereby acquit the accused from the charge under section 376 of IPC. Pass such any other order in favor of appellant as the Honorable High Court deems fit in the interest of justice, equity and good conscience. And for this act of kindness, the counsel on behalf of appellant as a duty bound shall forever pray. All of which is humbly and respectfully submitted by for the counsel for appellant. It was pleasure appearing before the court. Thank you.
I request the respondent team 11 to proceed with their submission.
That Riya agreed to a sexual relationship only after believing that Rajesh will be marrying her, which is after he proposed. After that, in para number 12, it has also been stated that despite being in a relationship, despite being committed to Riya, he asked his parents. Despite being committed to Riya, he asked his parents to find a suitable partner for him. After that, please refer to para number 13, where he made the wedding savings, which he had saved for their wedding. And later it was found out that it was transferred into a joint account with another girl named Maya.
In para number 15 of the fact sheet, it has been stated that he broke up with her and then sold the jointly purchased house without informing her. All these factors already prove the guilt of the accused. And I come to my next submission that that the accused is a proclaimed offender under INSS. Section 356(7) of the INSS states that no appeal shall lie against the judgment under this section unless proclaimed offender presents himself before the court of appeal. Proclaimed offender has not been present in this court of appeal. Hence, he can't take the stand to appeal, even though it is a statutory right, even though right of appeal is to be provided to the person who has been convicted. This man does not stand a chance to appeal since he is not even that much serious about this case, as he has not been presenting himself in this court of appeal. As you can please refer to the compendium tag number 1, where in Mahindra versus State, appeal was dismissed merely because the accused was not present before the Honorable Court of Appeal. The accused was absconded and therefore the Honorable High Court of Gujarat dismissed the appeal. Hence, I submit to you that this appeal is not maintainable before this court. If your lordships are satisfied with the first issue, I would like to raise the second issue.
How you will justify the conviction under section 375? As he has argued that it was a series of acts which come to an end in July 2024.
Yes,
And on that day, Bharatiya Nyaya Sanhita was already in operation.
yes, your lordship.
So why it should not be offence under 69?
Please refer,
Why under?
please refer to the tag 2 of the compendium, Tipu versus State of UP. It has been declared by the Allahabad High Court that any offence tag number 2, your lordship.
Can you please quote page number where it is mentioned?
Apologies, your lordship.
नहीं है वेगळं दिलं.
Page number 9. It has been stated by the Allahabad High Court that if any offence is committed prior to the enforcement of new criminal laws, then if the FIR is registered after the enforcement of the new criminal laws, then same will be registered under the provisions of IPC in the view of Article 20 of the Constitution, but the procedure of the investigation will be as per the BNSS, which has been duly followed by the Court of Session.
Facts are that lastly they were together in July 24.
Yes, your lordship.
In the end of July 24, end of July,
Yes,
he declared that I don't want to continue with the relations.
yes, your lordship.
So in the series of that, offence was committed by the end of July, whereas BNS was in operation on 1st of July.
Yes, your lordship.
See when BNS came in force,
Pardon, your lordship.
when BNS came in force,
1st July 2024.
and the case is of end of July 24.
Yes, your lordship, but the commission of offence, the start of the commission of offence was 1st December 2023, which is prior to the enforcement of the new criminal laws. Therefore, this case should be registered under IPC and should be followed by the procedure of the BNSS. Your
Then
lordship.
why offence was registered under 69 of BNS initially?
It may have been a little bit of a conundrum since the new laws came into the force. There was a confusion already going on if where to apply what, your lordship. So as per the investigation went on, as per they took the asked for extended remand, as per they conducted the investigation process thoroughly, they may have discovered that this offence actually falls under 375 read with 376 of the IPC instead of 69 of the PNS, your lordship.
One more question. This is a judgment delivered by 2 judges bench of Allahabad High Court.
Yes, your lordship.
Is it binding on 3 of us?
Pardon, your lordship.
Is it binding on 3 of us?
No, your lordship, but it is certainly of persuasive value.
It's not a binding precedent for us.
No, your lordship.
Proceed.
Council seeks permission for the to address the second issue. Second issue is whether the trial and was adhered to due process. The trial and was certainly adhered to followed. And section 84 it gives the proclamation of the offender. It has been clearly stated in paragraph 22 of the fact sheet that the requisite procedure under the INSS was followed, and after that only he was declared as a proclaimed offender. Therefore, since he was a proclaimed offender, there comes a possibility of trial in absentia happening, which further was contended and was fixed when the requisite procedure under section 356 of the INSS was followed. 356 of the INSS subsection 2 gives four procedures which are to be followed, and they have been followed. Basically, the issuance, I would like to point out that the execution of the warrant and the date of the issuance of the warrant can be both different. So, since in the fact sheet the date of the issuance has not been mentioned, counsel presumes that date of the issuance of the warrant was before the 1st of December. Yes, Your Lordship.
You are for prosecution.
Yes, Your Lordship.
You have to prove the case beyond reasonable doubt.
Yes, Your Lordship.
You cannot presume anything.
Yes, Your Lordship.
So if your argument is accepted as it is, it will be saying that as there is compliance of section 84, section 359 is not required to be followed. Do you want to mean that?
No, Your Lordship.
Then
But the same.
only declaration of proclaimed as absconding is suffice to proceed against the accused in absentia.
No, Your Lordship.
So there has to be procedure, that procedure is provided in the 359,
Yes.
which was not in CRPC earlier.
Yes, Your Lordship.
Trial in absentia was not known to the CRPC. Now it is introduced in BNSS.
Yes, Your Lordship.
So you have to read both the provisions and you have to follow both the provisions in strict sense.
Section 356 of the INS has been duly followed, Your Lordship.
How?
Subsection.
Because as far as this case is concerned, it is nowhere stated that he was given right of representation.
Pardon, Your Lordship.
He was given right of representation. Rojes was given right of representation before the court because he has right to appoint advocate of his choice. That is first law. If he is declared absconding, then there is a provision under 359(3) which says that court has to appoint the advocate on behalf of legal aid.
Yes, but
That is silent on as far as this case is concerned.
Your Lordship.
Then how we can say that there was adherence to 359?
Your Lordship, there was adherence to 356 of the INSS.
How?
Because the accused is absconding, even though he is
True, he is absconding. We will admit that he was absconding, therefore proclamation was there. What is about his right to be represented?
It surely is there, Your Lordship, but there is also even in 356 subsection 7 that the accused himself should be present before the court of appeal while filing for an appeal. So if he himself is not present before this court of appeal, then there stands no chance for.
No, that is about maintainability of appeal. I am not about maintainability of appeal. I am about maintainability of conviction.
Yes, but he was given the opportunity to hear.
In the teeth of non-adherence to 356(3), conviction would vitiate.
No, Your Lordship.
How you will justify that?
Yes, because since there two warrants, consecutive warrants were also issued against him, were tried to be executed but couldn't be executed since he was proclaimed. Second, published in the local daily newspaper.
Where is that?
Fact sheet is silent about that, Your Lordship. The same for the clause numbers 3 and 4, the fact sheet has been silent.
Okay, proceed further.
If Your Lordships are satisfied with the second issue, I would like to address the third issue. Third issue is whether the lower court's application of substantive and procedural laws appropriate. It is humbly contended that the Honorable Court application of substantive and procedural laws was totally appropriate. The application of, as I already mentioned, that case of Deepu versus State in my complaint, if the offence is committed before the date of enforcement of the new laws, then it is to be committed with IPC, and the procedure is to be followed by the process of BNSS, which has been duly followed. My next submission is section 531 of the BNSS, which is repeals and savings. It is duly mentioned in subsection 2 of section 531 that if immediately before date on which Santa comes into force, there is any appeal, application, trial, inquiry or investigation pending, then such appeal, application, trial, investigation shall be disposed of and continued or held as case may be in accordance with the provisions of Code of Criminal Procedure 1973. This is not a pending appeal, Your Lordship. This is a fresh appeal. This is a fresh case which was registered after the enforcement of the new law for the commission of offence which has happened before the enforcement of new law. Therefore, this section also comes into force and hence proves that the process of law, the application of substantive and procedural laws was duly followed.
So don't you think that this section 531 is contrary to section 4?
Pardon, Your Lordship.
No, section 4 of BNSS.
Section?
4 of BNSS. See section 4 of BNSS. If your argument is accepted, section 4 will be redundant. Read section 4.
Trial of offences under Bharatiya Nyaya Sanhita.
Only subsection 1 is required.
All offences under Bharatiya Nyaya Sanhita shall be investigated,
Slow.
inquired and tried into, otherwise dealt with according to the provisions herein after contained.
Read once again. All offences under Bharatiya Nyaya Sanhita.
But this offence isn't registered.
Just read first.
All offence under the Bharatiya Nyaya Sanhita 2023 shall be investigated, inquired into, tried and otherwise dealt with according to the provisions herein after contained.
Now come to section 4 of CRPC. Section 4, subsection 1.
All offences under IPC 1860 shall be investigated, inquired into, tried and otherwise dealt with according to the provisions herein after contained.
So you are trying under section 375, which is in IPC,
Yes, Your Lord.
and proceeding under BNSS.
Yes, but see,
So how section 531 will apply in this case? We have to go by section 4, and if we go by section 4, trial itself is nullity.
now no other procedural law was in force.
CRPC was there.
CRPC was in force.
CRPC was there.
But when the BNSS came into force, CRPC was already repealed. So after the and it was held by the courts that if the offence is committed and before the commencement and if the FIR for the same has been filed after the enforcement of the new law, the case should be filed under the old laws and the procedure should be established according to the new laws. Your Lordship.
Okay.
If your lordships are satisfied with the issue, I would like to call my co-counsel for the further explanation. Much obliged.
Speaker number 2 on behalf of PC 11. I will be dealing with issue number 4 and issue number 5. The lordship I seek permission to proceed with issue number 4. The lordship issue number 4 talks about was the charge of rape correctly applied. My lordship, finally refer to page number 16 of the memorial for the respondent. I have mentioned the ingredients of the offence of rape under 375 of the IPC. Your lordships, a man has the ingredients of rape. I'll just read it out. A man has sexual intercourse with a woman. Such intercourse falls under one of the 6 clauses of the section, and the case does not fall within the exceptions to this section. My lordships, the learned counsel for the appellant have already admitted in their submissions that the offence of rape or the offence was committed in a series of events which started from the 1st of December in 2023. Your Lordship, this satisfies section 376N of the IPC. That is punishment for rape, commits rape repeatedly on the same woman. And Your Lordship, the punishment for that is also mentioned, shall be punished with rigorous imprisonment for a term which shall not be less than 10 years but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of the person's natural life and shall also be liable to fine. Your Lordship, along with the ingredients of the offence of rape, I may also point out that the consent which the learned opposing counsel have contended that the consent was, the intercourse was consensual. Your Lordship, the consent has been obtained because of misconception of fact as section 90, as mentioned in section 90 of the IPC. Lordship, I'll just read it out. Lordship, consent known to be given under fear of misconception. A consent is not such a consent as is intended by any section of this code if the consent is given by a person under fear of injury or under a misconception of fact. If the person doing the act knows or has reason to believe that the consent was given in consequence of such fear or misconception. Now, Your Lordship, I humbly request you to come on page number 17 of the memorial for respondent. Your Lordship, in Salia Khatun versus State of Bihar, it was said that consent obtained by deceitful means is no consent and can clearly be established that the offence comes under the definition of rape. Your Lordship, in the present matter, if we peruse the facts of the case, it can be clearly established that a consent was only based on a false promise to marry rather than the breach of promise.
Pardon?
Your Lordship, if we peruse the facts of the case, it can be clearly established that a consent obtained was subsequent to a false promise of marriage, nor true promise which then
If your argument is accepted as it is,
Yes, Your Lordship.
and if we believe that consent was obtained subsequent to the sexual relations,
No, Your Lordship. What I am contending is the consent which was obtained was based on a false promise of marriage and not a breach of promise.
so do you agree that the series of offence which incorporated in this case ended in the July 24?
Yes, Your Lordship.
So it was a series of activities.
Yes, Your Lordship.
Whether they were in relation till the end of July, that is silent. So we have to presume that there were relations till July 24.
Yes, Your Lordship.
New Act came into force on 1st July.
Yes, Your Lordship.
Whereas after commencement of new Act, for 30 days they were in relation.
Your Lordship,
Okay?
yes.
So why not section 69?
Your Lordship, the date of commencement of offence, to notice the date of commencement of offence is much necessary, and the consent which was there, which
It was continuous. It was continuous.
yes, Your Lordship, I am coming to that. The consent which was there was obtained on a misconception of fact, and that happened prior to the application.
So misconception means consent was obtained on the ground of promise of marriage,
false promise of marriage.
and therefore separate offence is provided under section 69 of BNS.
Yes, Your Lordship. But
So why prosecution not under 69? Why under section 375 IPC?
Your Lordship, the date of inception of offence, that is
That was till July 24,
no, Your Lordship.
and on that day BNS was in operation.
Your Lordship, Your Lordship, point number 9 of the on 1st December 2023, Rajesh proposed to Riya, promising marriage by the end of 2024. Your Lordship, trusting his commitment, Riya agreed to a sexual relationship, believing in their impending marriage. Your Lordship, the counsel for the petition, the appellant have already admitted that the offence was committed under series of events. Your Lordship, the inception of the offence was from the 1st of December, and at that time, the applicable law,
I am not asking about starting point of offence.
yes,
Ending point is July, end of July.
Your Lordship, the fact sheet is silent about the ending point.
Yes, please conclude yours.
May I proceed with the next issue? Your Lordship, issue number 5, that is, was the repeated extension of police remand lawful considering May I proceed? Your Lordship, was the repeated extension of police remand lawful considering constitutional protections? Your Lordship, if I may refer to section 187 of the subsection 2 of section 187, the magistrate to whom an accused person is forwarded under this section may, irrespective of whether he has or has no jurisdiction to try the case, after taking into consideration whether such person has not been released on bail or his bail has cancelled, authorize from time to time the detention of the accused in such custody as such magistrate thinks fit for a term not exceeding 15 days in whole or in parts at any time during the initial 40 days or 60 days out of detention period of 60 days or 90 days as the case may be, as provided in subsection 3. Your Lordship, the offence that that has been committed in this case, it has a penalty or it is punishable with imprisonment for life. Therefore, Your Lordship, the maximum amount of remand that can be granted under the BNSS is 90 days. Your Lordship, in the present matter, the procedure followed, that is the grant of remand, it started from the 16th of August. Consecutively 15 days were granted, and Your Lordship, the remand was granted in a cyclic matter. So Your Lordship, due adherence to the procedural and substantive law has been there in terms of this case.
Come to prayers.
Yes, Your Lordship. In the light of facts stated, arguments advanced and authority cited, the counsel for the respondent humbly prays that this honourable court to declare that this appeal shall be dismissed with all cause, that the conviction placed by the honourable session court shall be upheld.
Take a slide next.
15 बाकी 15-20. Okay, you can leave. Okay, it's okay. You can leave.
That's mine.
Hello.
व्हॅलिडिटी आहे तर 5 लाख देऊन संपलं. Yes, come. Yes, please.
I request the appellant team 15 to kindly proceed with their submission. The council seeks permission to address the bench as Your Honor.
Speaker number.
I am speaker number 1. Much obliged. Your Honor, the council would like to bring your attention that there has been an error in the present submission from page number 16 to page number 17, and the same error shall be addressed by my co-counsel. It may please your Honorable Court, I am the counsel on behalf of the appellant in the matter of Mr. Rajesh versus the state of Aryapur. The council seeks permission of Your Honor to proceed with the statement of facts.
You can skip the facts.
Much obliged, Your Honor.
You can directly go to the advance argument.
Your Honor, could you please repeat that?
Directly come to point number 1.
Much obliged, Your Honor. Your Honor, I am written number 1 and I will be taking up the cases of issue number 1, 2 and issue number 3. Your Honor, the council seeks permission to proceed with the arguments advanced.
Yeah.
Your Honor, in issue number 1, is the appeal maintainable before the High Court of Aryapur? Your Honor, I would like to state a ratio by Blackstone which says that it is better that 10 guilty persons escape than 1 innocent person suffer. In this case, the appellant, Mr. Rajesh, has been charged for a crime of under Article 365, Level 367 of the Indian Penal Code, which is the INS at the moment, INS 2023. The appeal is maintainable under the Code of Aryapur due to the Section 415, subsection 2 of the INSS, which states that any person convicted on trial by a sessions judge or an additional sessions judge or on a trial held by any other court in which the sentence of imprisonment for more than 7 years has passed against him or against any other person or against any other persons convicted at the same trial, he may appeal to the High Court. The grounds for filing an appeal. Under the INSS, there are several grounds on which an appeal can be filed against the decisions of a lower court. The grounds generally include, but are not limited to, procedural errors, perversities, improper admission or rejection of evidence, violation of legal principles, excessive sentencing, and errors of facts. Your Honor, the council will like to bring attention to perversity. This refers to a decision by the lower court that is so unreasonable that no reasonable person could have come to such a conclusion based on the evidence presented. So in this case, the police did an investigation on the appellant during the period of 14th August to 14th November. So during this entirety of the period, in the statement of facts, it is exclusively stated that he was being tortured and coerced to give evidence. He was forced to confess. And after the 90 days period, after he had gotten his default bail, police has charged a charge sheet convicting him of such crimes. Now, Your Lordship, Your Honor, I would like to point out that under Section 120 of the INS, which refers to the When an evidence is obtained through coercion or torture of a person, the validity of that very evidence is in question. So when the charge sheet was filed again under 376 against the appellant, the validity of the charge sheet is in question because during the process, if the police had to resort to torture and coercion, then the contents of the charge sheet, the validity of those very contents is in question, Your Honor.
But conviction is not on the basis of that extracted confession.
Your Honor, could you please repeat that?
You want to convey that conviction is not sustainable because he was tortured in the custody and confessional statement is taken up from the accused. That is what your submission is. Am I right?
Your Honor, I couldn't quite get that. Could you please repeat it?
You want to say that conviction is not proper because it is based on the confession given by the accused during the police custody and he was forced to make this confession.
Yes, Your Honor. The very fact that it was stated that the police had to resort to torture and coercion to get the appellant to confess.
But conviction is not based on that extracted confession because that is extrajudicial confession.
Much obliged.
Do you mean to say that the conviction is based on confession?
No, Your Honor, I do not mean.
Just you have argued that.
Your Honor, I do not mean that the conviction is based on that very fact, but the charge sheet, which is the very beginning of this proceeding, can be put in question due to the practice that has been conducted by the police and their procedures.
So, during the course of police custody, you were time to time produced before the court. You have not made any complaint against the police about the torture in the jail, in the custody.
Your Honor, the appellant was, the police had approached the courts to renew their remands.
In your absence? Do you mean to say in your absence the custody has been extended?
Indeed, Your Honor.
It cannot be. Cannot be. He has to be produced before the court or magistrate. And then only custody will be increased, extended. And at every time you have chance to say that I have been tortured in the jail. Police are harassing me. Police are compelling to give a self-incriminatory statement. That all these facts are lacking. Now you are taking defense only for sake of defense.
Indeed, Your Honor, but at that moment, the appellant had not in fact mentioned that he was being...
Come to page number 11. You have given a reference of Ajit Sawant versus State of Karnataka. How this case will be relevant to your matter? Honorable Supreme Court has held that court's conclusion, if unreasonable or perverse, then conviction is unsustainable. That is settled position of law. There is no question about that. But how you can argue this because you were absent? You were absconding during the trial. You are not cross-examining the witness of prosecution. You are not laid any defense evidence in support of your case. Then how you can say that the conclusion drawn by the trial court is unreasonable when there is no evidence at all at your level, no cross-examination at your hand. So court has to believe the statement given by the prosecution witnesses and supporting with the charge sheet along with section statement under section 161.
Your Honor, under section 356(2) of the INSS, I would like to state an extract from the very section. Your Honor, section 356 of the INSS is relating to inquiry, trial, or judgment in absentia of a proclaimed offender. The subsection 2, the court shall ensure that the following procedures have been complied with before proceedings under subsection 1, namely, issuance of 2 consecutive warrants of arrest within the interval of at least 30 days, publishing of a national and local daily newspaper circulating in the place of the last known address of the resident, requiring the proclaimed offender to appear before the court for trial and informing him that in case he fails to appear within 30 days from the date of such publication, the trial shall commence in his absence. Your Honor, nowhere in the statement of facts has it been stated that any publishing in a national or local daily newspaper has been circulated. Therefore, in the case that the appellant has changed his address temporarily due to either fear or coercion from the police, he will not know that he has the cases that have been brought against him.
Though the facts are silent on that aspect, publication of a proclamation under the newspaper 356 you are reading. But go to point number 24. It says that our requisite procedure under BNSS was followed. Court has to presume that after following the procedure only, he was committed to the session court. Why should we disbelieve the magistrate or the case of prosecution when you are not attending the case? You are absconding from the justice, from the court of law.
Your Honor, but if the appellant is not aware that there have been proceedings brought against him and he is not in that particular position and there is no way of him knowing that there have been a proceeding brought against him, how can he be stated as being absconding if he has no knowledge?
For 90 days, madam. You were under police custody for 90 days. After 90 days, you are released on deferred bail. So how you can say that you don't know about the trial or pending against you and you don't know anything about trial?
Your Honor, if the appellant, in his good faith, is afraid due to his custody, during his custody, when he was abused and was coerced into giving a confession, he will not stay in the same location that he was living in due to the fear that the police may come and abuse him at his residence.
Once he is released on bail, there is question of police coming to his house and troubling him.
Your Lordship, I couldn't quite...
If after 90 days he was released on default bail
Yes, Your Honor.
and thereafter charge sheet was filed. So once charge sheet is filed, where is question of police coming to your house and troubling you and therefore you are required to change the house?
The counsel pleads ignorance, Your Honor.
Proceed further.
The council seeks permission to proceed with issue number 2 and 3, which the council will taken as one issue. The council on behalf of the appellant would like to state that the trial of the appellant that was held in absentia did not adhere to due process as it has been laid down in the INSS. Neither was the remand proceedings nor the conviction of the appellant adhering to due process laid down in the INSS. The appellant has been convicted by the court without proper process being followed and without proper investigation being done. Therefore, the lower court's application of substantial and procedural laws was not appropriate. Your Honor, under section 356 of the INSS 2023, which I have mentioned earlier, the publishing in the national and daily news was not done. And also, I would like to bring your attention to section number 187 clause 3 of the INSS. Your Honor, the section 187 clause 3 of the INSS states that the magistrate may authorize the detention of an accused person beyond a period of 15 days if he is satisfied that adequate grounds exist for doing so. The law magistrate shall authorize the detention of an accused person in custody under the subsection for a total period exceeding 90 days where investigation relates to an offence punishable with death, imprisonment for life, or imprisonment for a period of 10 years or more, and 60 days where the investigation relates to another offence. Your Honor, I would like to bring the attention to the part where it says that if he is satisfied with adequate grounds that exist for doing so. Your Honor, I believe that there are no adequate grounds existing because throughout the cyclic remand, over and over, the police has not been able to get enough evidence through their investigation to keep on asking for a remand. The police was unable to get proper evidence, essentially, Your Honor. They had to keep on asking for a cyclic remand exceeded to the limit of the 90 days that has been provided, and after which they filed a charge sheet. So, Your Honor, the question lies whether there was adequate grounds for the magistrate to provide the cyclic remand. For the first cyclic remand, for the second remand, for the third remand, it would have been understandable, Your Honor, but reaching the limit of 90 days and still not being able to file a charge sheet on time, Your Honor, that puts a question on how well the investigation of the police was, that they had to file a charge sheet exceeding the limit of 90 days. And once exceeding the limit of 90 days, they know very well that the appellant can file for a default bail. So they have not conducted thorough enough investigation that they could file a charge sheet for the. Your Honor, now the issue number 4 and 5 will be taken up by my co-counsel.
The co-counsel would like to proceed with the issue number 4. Much obliged. Your Honor, it may please be Honor that I respectfully submit that there has been an inadvertent error in the memorial submitted with respect to issue number 4, which I will be dealing with today. I request the court, honorable court, to consider my oral submission as the accurate representation of my appellant's case on this matter, on this issue. The fourth issue was whether the charge of the rape was correctly applied or not. Now, when we go to the section 375 of the Indus Penal Code, it very well says that if there is no consent, then it amounts to rape. Whereas in the present case, the Rajesh and Ria, my appellant and the respondent, they both had the consensual relationship between the both, and there was consent from both Ria as well. And where the finances which led to them between both which do not apply to the rape. Next, the thing is, the Ria's consent was given voluntarily and without coercion. Now, the consent under 375, you see, only vitiates if it is obtained through force, fraud, or under influence. Now, in the case which I like to mention, the case is Pramod Suryabhan Pawar versus State of Maharashtra. The Supreme Court had held that a false promise of marriage that induces the consent for sexual intercourse with the accused has never intended to fulfill the promise amounts to rape. Whereas in the application to the present case, there was a consensual relationship between the both. There has been no fraud, there has been no coercion, and there was no intention that he will not marry from the inception, which proves that it does not amount to rape. The breach of promise to marry does not automatically amount to rape. The court held that breach of promise and false promise are two different things. A false promise may be in the inception where he is not intended to marry, whereas the breach of promise may be due to the external factors, maybe like a family pressure or the financial issue. I'd like to mention to the case of Anurag Soni versus State of Chhattisgarh.
Ma'am, how will justify that according to you there was a consent, but this is the charge against you that the consent was under deceptions. You have obtained her consent keeping her a dark. Since inceptions you were not intent to marry her. Your behavior or since beginning, whatever act you have done or the omissions you have done, from that only it has been concluded that you are not intended to marry her. Just because to fulfill your own sexual urge, you have kept her in the dark, you have forced her to pay the money, you have purchased the flat in your name, you haven't purchased the flat with a joint name. After that you have withdrawn that money, you have transferred that money in the account of a Maya. So why can't it be presumed that the consent was not free consent, you kept her in a dark? So how the court is wrong presuming that the consent was under coercion?
Your Honor, the first thing in this is the joint house and the finances. Now in the inception only when the proposal between the Rajesh and the Riya was there, they had intended of marrying in future. But due to the external effect, that is the family pressure on the Rajesh, made them to part apart.
So what efforts you have done returning back her money? You agree that the house has been purchased with the money, or both have contributed for that house? What have you done with that house? You have sold out.
Your Honor, if there was no intention if there was intention of deceiving the Riya from the beginning only, then the Rajesh would have not paid the half of the finances. They would have not bought the house in the joint. So there was no consideration that will amount that he has made a deceitful act. And as per the case of Dr. Program Murlidhar Sonar versus State of Maharashtra, the Supreme Court clarified that the act was genuinely intended to marry but later failed due to external reason. It will not amount to rape. However,
Intention cannot be seen. It is not visible. So we have to gather the intention from the facts and circumstances of the case. And as my learned sister has posed a question that you have withdrawn the amount, you have stipend that amount to the account of Maya, you have purchased the home from the earning of yourself as well as Riya, but not recorded name of Riya in the sale date, and it was purchased in your sole name. Thereafter you sold that house. What it indicates?
Your Honor, when the house was taken on the name of the Rajesh, there was Riya who was present, and with the consent of her, the house was registered.
And how you can sell out the house without her consent and without informing her?
In the matter, Your Honor, in the matter where Rajesh had financial problems which he was facing. So on that pretext, he sold that house. Where in a relationship there can be a financial problem between them, and that one partner can have the share of it. Though in this case the Rajesh had fully taken the amount and as well as the house, whereas he was in need of those amount. So when the Riya might ask her about this, he may give it to them. In this case, there was no fraudulent thing here, anything. The only thing that he was in need of those money and due to some extent.
How you justify? You have transferred that amount into the account of Maya. When you were in a difficulty, when you had financial difficulty, you haven't utilized that amount for your own benefits.
And even you are not sought permission of Riya for withdrawing the amount, when that amount was also contributed by her.
Your Honor, about
Kindly conclude yourself in 1 minute. You have already exceeded your time. Please.
conclude
Come to prayers.
and issue 5.
You have already exceeded the time.
So,
Yeah.
So you
then
can
we
come
may-
to prayers.
prayer.
Yeah.
Your Honor, counsel seek permission to proceed with the prayer. Therefore, in the light of the facts above stated, arguments advanced and the authority cited, the appellant most humbly prays before this Honorable High Court to graciously please to declare that the appeal is maintainable before the Honorable Court, to declare the trial in absentia did not adhere to due process, to declare that the lower court application of substantive and procedural laws was not appropriate, to dismiss the charge of rape against the appellant, to declare that the repeated extension of the police remand was unlawful, and or pass any other order that it may be placed to in the interest of the justice, equity, and the good conscience. And for the act of the kindness, the counsel on the behalf of the appellant shall duty forever free.
Thank you. Yes, please. Respond.
I request the respondent team 20 to proceed with their argument.
Mic check. The counsel of the respondent solicits permission to begin to address collectively the benches, your lordships. Much obliged. If the lordships are well versed with the facts, should the counsel proceed with arguments advanced? Much obliged. Counsel number 1 would be dealing with 3 issues at hand, first, second and third. The rest would be taken by my co-counsel. Much obliged. The first issue is the appeal maintainable before the High Court. The respondents humbly submitted before this Honorable High Court that the people approach judiciary not because of due process it follows, but because of the rule of law, because of the interest in justice, because of the ray of hope that judiciary possesses. The respondent humbly submits that though the appellant has a statutory right under section 405 of BNSS to appeal before the Honorable High Court, but this right is not absolute and it must be weighed according to the needs and circumstances of the case. The appellants in this case is trying to use this right which is given by statute to cause a grave miscarriage of justice, which I would be providing 3 reasons for the same. The respondents humbly submitted that the appellant voluntarily absconded the trial, and if the lordships currently allow this appeal, it will send a bad precedent to the people that look before the judiciary as a ray of hope, because it will send a message that okay, the trial in future could be conducted at a lower courts and an appeal could be maintained at a higher court. This would set a bad precedent not only for the other people but even at a lower organ of the judiciary. How? The respondents humbly submits that since a statute right is mentioned in section 415, it can be used as a weapon by the appellants, by the accused person, to voluntarily abscond from the trial and appeal at a later stage at a higher court, thereby abusing the process of justice involved in this. I would like to cite a case of Honorable Supreme Court, that is Pandra Mitchell Kevne vs. Bharat Sanchar Nigam Limited, which categorically held that access to justice is not absolute and people must exercise this right in good faith. The emphasis is laid down on good faith. Further, I would like to clarify that even this appeal, even if this is allowed through a statutory right, it is a grave violation of natural justice laid down in Maneka Gandhi's Union of India. Justice delayed is justice denied. This is a grave case of rape.
But justice hurried is justice buried. What about that?
Precisely, my lords. Justice hurried is justice buried. But
Then
what? Exactly, my lord. But this is a case of involving rape and heinous crime. What this says is that the victim is already suffering from 2 trials, that is at the Sessions Court and now at the High Court, just because the accused person, the convict at the Sessions Court, tried to voluntarily abscond this trial. With this, I would like to move on to issue 2, if my lord is satisfied with the submission.
So you want to say that there should not be right of appeal?
Precisely.
And there should not be this hierarchy.
Precisely not.
So once there is a conviction, it is always conviction, and it is not subject to correction by appellate court or by the High Court or Supreme Court.
My lord's grave error of justice or any facts must be corrected through an appeal, and it is a right which is
Appeal not necessary. My grave error of justice can be corrected under revisional jurisdiction, either by the Session Court or by the High Court.
Precisely.
As far as appeal is concerned, he accuses every right of arguing everything under the sky.
Precisely, my lord.
So there is not, that it is not necessary that only in grave injustice cases only appeal would lie. And appellate court should exercise the jurisdiction on those cases only. The rest of the cases has to be dismissed.
Precisely, my lords. The respondents humbly argued that since in the interest of justice, since the victim is already subject to 2 trials, the case must be looked at the merits of the case. But for this, I would like to move on to the second issue, which is, did the trial in absentia adhere to due process? And I would like to club this with the third issue itself, which is, but the lower court's application of substantive and procedural laws appropriate. Now the respondents humbly submits that trial in absentia adhere to due process as prescribed in the Indus-Land Nagari Swacha Sanhita and was conducted in a fair and just manner. The section 356 subclause 1 explicitly allows for a fair trial in absentia provided certain conditions are met under subclause 2. Now before I move on to the BNSS, I would like to state that under the previous old laws, the Supreme Court in Hussain v. Union of India held that certain amendments are needed in Criminal Procedure Code 1973 to allow trial in absentia for a speedy justice. And now since the new laws have came in, we are looking at the BNSS, which has this provision under section 356. Now it is very clear from Moot proposition para number 22 that the procedure laid down in the BNSS subclause 2, that is 2 consecutive warrants, an advertisement, and related information was properly adhered to. Now first, I would like to state a provision before the Honorable Bench that Section 356 subclause of BNSS explicitly states that when the person has absconded the trial and there is no immediate prospect of arresting him, it shall be deemed to operate as a waiver of right of such person to be present. I would like to also move on to a submission that the trial absentia not only adhered to the necessary safeguard provision of 356 subclause 2, but even the 90-day waiting period was provided to the accused so that to uphold the interest of justice, we live in a country where even the Kasab was awarded an opportunity to argue the case, and this is a case of rape. So even after this opportunity, the appellant consecutively voluntarily absconded from trial. Now moving up to submission of the sub-issue 3, which is basically that we define arrest in the law terms as a custody as empowered by law for the purpose of holding or detaining from answering a criminal charge. This is the definition given by Ratnalal and Juranjalal. The respondent humbly argues that the gravity of the crime must be assessed when we are talking about due process of law. What the respondent side humbly argued before this honorable bench is that this is not a just case of rape. This case not only involves rape. This case involves a breach of trust, a breach of relationship, a personal grievance to the victim. That is Ria in this case, who not only entrusted his boyfriend Rajesh with the responsibility to manage joint account, but also the responsibility to see a future with him.
Where is case of breach of trust? Have you applied section 406 in this case? And if not,
my lords, the respondent have not applied this, but in the oral submission I would like to clarify that this is not just a case of rape, but the gravity of this is much bigger. So that's why I mentioned, I apologize for adding something which is not mentioned. I would like to also cite section 84 of INSS, which provides that if a court has sufficient grounds to believe, either with or without taking the evidence, that a person against whom a warrant has been issued is evading, absconding or hiding, thereby preventing the execution of the warrant, the court may issue a public proclamation, which is a near 356, to proceed with the trial in absentia. And this is precisely the case beforehand. In this case, even after 2 consecutive warrants, the police was not able to trace the Rajesh because he was consecutively absconding. My lords, I would like to state a couplet to categorically state the situation if I have the permission of this court. This is a couplet by Munawwar Rana which states that बादशाहों को सिखाया है कलंदर होना, आप आसान समझते होंगे मुनव्वर होना, एक आंसू भी हुकूमत के लिए खतरा है हुजूर, आप ये नहीं जानते एक आंखों में है क्षमता समुंदर होना. What this states that even a drop of tear from the victim Ria might be sitting under when there is only a single person, but this not only involves the faith of people in the entire judiciary, but also the faith of nation, because judiciary is not something which is regarded as only a statute. It is known as an interpretation mechanism to provide justice even at the circumstances when the law is explicitly not provided. Further, I would like to conclude.
So your submission is that without trial also, or without proper procedure, without following due procedure of law or the trial, somebody can be convicted only to see that the victim should be happy for that.
My lords, it is very crucial to ascertain that both the parties have a right to trial, both the parties have a right to fair trial. But what the respondent humbly submits is that when a case is of nature of such nature and the person is consecutively awarded the chance to appear before the court and still the person is absconding, still the person is, it is even from the Moot property is clear that even the savings of the joint account were transferred. In such cases also, so judiciary has to follow the due process.
What is the standard of proof in criminal trial?
Again, my lords,
Because if your argument is accepted as it is, this is like a civil case. Standard of proof in criminal is beyond all reasonable doubts. Whereas in civil matters, it is beyond the preponderance of probabilities. So if your argument is accepted as it is, you want to see that this criminal trial should be at the level of civil court trial.
my lords, precisely due process has its own importance, especially in the criminal cases, and that is precisely
And therefore, in criminal law, it is duty of the prosecution to prove the charges. It is not duty on the shoulder of the accused to prove something. He is not required to prove anything unless the offences are having presumption under the law.
precisely, my lords,
And
and
375 there is no presumption under law.
precisely, my lords, that is a very important observation to be made, that in criminal law due process is as important as the rule of law, and that is the reason why section 84 of BNSS, which includes public proclamation, section 356 subclause 1, section 356 subclause 2, which lays the procedure to be followed, has all been adhered to ensure that the accused or the convict in the trial court's case has reasonable opportunity to argue the case, the 90-day cooling off period, the 2 consecutive warrants, and it all ensures that the appellant in the present case had the right before the trial, before the sessions court itself, to argue before and clear their stance. But also, I would like to state a case of Delhi High Court, that is Vikas Yadav versus State of UP, which states that rights available to the accused does not extend to the abscondents. On the contrary, the law postulates such person to make themselves available to the police which is searching for them. It basically ensures that all the rights that we are talking about is universal to all its citizens. But if a person is absconding, if a person is constantly trying to evade justice, trying to evade due process of law, we have to ensure that certain time limit is given to them, and even after such time limit, even if that person is absconding, we have to uphold the rule of law and begin with the trial.
Yeah, make a submission on a next point because you have substantial argued on this point. Yeah, please.
Precisely. I would like to conclude my submission on summarizing the key points that I have made, is that the procedure laid down under section 356 subclause 1, subclause 2 was duly adhered to as mentioned in the prop itself, para number 22. The section 84 public proclamation was extended to, which is properly adhered, and it could be ascertained from the prop itself or from my submission itself that the appellant had reasonable opportunity to make themselves appear before the sessions court and to allow the proceeding of the justice. I therefore extend the other submissions to my learned co-counsel.
Greetings to your lordship. I will be beginning with the fourth issue. Much obliged. So the fourth issue is that the charge of rape was correctly applied. So the respondent humbly submitted that the charge of rape was correctly applied, as Rajesh, the appellant itself was obtaining consent of the complainant through deceitful means. Now, your lordship, I have divided my issue in 2 sub-issues, which is completely going to dismantle the appellant's argument that the consent was not obtained through deceitful means, or the consent was not obtained for a purpose which was not for to take the undue advantage of the victim. Your lordship, first I would like to submit that section 90 of the Indus-Land Penal Code says that consent is not a consent as it is intended by any section of this code if the consent is given by a person in the fear of injury or under a misconception of fact. Your lordship, this section is going to be clubbed with section 375, which is usually the precedent for governing such laws regarding false promise to marry or obtaining sexual intercourse of a woman through deceitful means. Your lordship, it is an evident fact that rape itself is defined to a sexual activity done by a man to a woman without her consent, and by including section 90, where consent is being included under the misconception. The respondent is humbly arguing that the appellant has raped the complainant, and therefore the charges posted by the Sessions Code are completely valid. Lordship, I would like to
How can you justify that the consent was misconception? You have spent a longer period with the accused. You stayed with him in a living relationship. You were knowing that how that person is. Despite that, you have consented for a physical relationship. Despite that, you have consented for the marriage. How can you say that the consent was obtained under misconception?
Your Ladyship,
It's not that that person has proposed you and on the same day he proposed you to have a marriage, because you have spent substantial time with that person. You stayed with him for more than a year or 1.5 years in a living relationship. At that time there was no questions of marrying with each other. The things were clear that you people will live together in a living relations. Whether the question arose at that time that you people will marry, after that, after substantial period only he has proposed to you. You were knowing that how that person is, despite you have consented that. How this consent will be misconception?
Your Ladyship, I completely agree with what you are saying. However, I would like to refresh the scenario here. If we go to section 9, to the paragraph 9 of the Moot proposition, I would like to reiterate here. On 1st December, Rajesh proposed to Riya, promising marriage by the end of 2024. I quote, trusting this commitment, Riya agreed to a sexual relationship. So the respondent humbly submits that while Riya and the appellant were living together, it was only after this proposal that Riya agreed for a sexual relationship. So Your Ladyship, what the council is trying to humbly submit here is that the very foundation of this relationship, this sexual relationship, was based on marriage. And this marriage, as proven in the later paragraphs of the Moot proposition, for example, 16th paragraph, where Riya discovered that Rajesh has sold the jointly purchased house and transferred the property to his joint account with Maya. And further, in the 14th paragraph, where Rajesh decided to end the relationship, it was after transferring the funds to his own account. It was after selling the house, and after completely violating the dignity of Riya. The respondent humbly submits that it is after all of these heinous crimes he has done, then he has established this fact. So, Your Ladyship, continuing with my submissions, it is argued that the appellant misappropriated the facts to compel the complainant to agree for a sexual relationship, therefore seeking consent through deceitful means. It is a well settled law that consent obtained through deceitful means is not consent at all, and therefore the appellant must be charged with section 375 and 376 of the Indian Penal Code. Ladyship, I would like to extend my submissions by quoting a judgment from the Supreme Court, which is Deepak Gulati versus State of Haryana. It is a 3-judge bench judgment where it was held that any consent given under the misconception of fact, which I have already reiterated, that is not consent at all. Another submission, Your Ladyship, is that the pattern of deceptive conduct was shown in the prosecution's case, in the appellant's case. So, Your Ladyship, as I have already established the facts that Rajesh deliberately moved the savings to his own account, and when Rajesh's parents asked for marriage, he told them to find a suitable partner. He was already living in with Riya, he was already having all the sexual relationships with her, he already purchased a house, and he was already having a joint bank account with her. Even after all of this, he asked his parents to find a suitable match. So, Your Ladyship, with this the respondents humbly submit that the very intention of the appellant was to deceive Riya from the very beginning. Your Ladyship, with this I would like to move to the 5th issue, which is regarding the repeated extension of the remand. It is submitted that the repeated extension of remand is completely under law, and section 187 of the INSS states that if the magistrate is satisfied, and I'm not going to reiterate the irrelevant things, I would like to just reiterate section 187 clause 1 and clause 3, that 90 days where the investigation relates to an offense punishable with death, imprisonment for life or imprisonment for a term of 10 years or more. Your Ladyship, the imprisonment of life was a just. It has already been established in section 376 of the Indian Penal Code. And therefore, by this 15 days of extension were always granted by the police for the grounds of investigation, because it is a very heinous crime, and as justice delayed is justice denied, justice hastened is justice buried.
How custody for more than near about 90 days PCR? Under which law it is permitted?
Your Lordship, it is under section 187 of the INSS. Further, it is also protected by Article 22 Clause 4 of the Indian Constitution, where a person cannot be detained for more than 90 days.
No. I am asking that how PCR for more than 15 days? How it is sustainable?
Through seeking extensions.
How? Under which provision you can have a police custody remand for 90 days?
It was not for 90 days, it was for 15 days, and after 15 days the extension was sought through magistrate.
So what is the ceiling of PCR? For maximum how many days PCR can be granted?
90 days, Your Lordship.
90 days?
For maximum, like all those extensions can be taken till 90 days, and after that the appellant is eligible for default bail. But for one iteration, only 15 days is the maximum limit. After 15 days, an extension is to be sought on the grounds of incomplete investigation or reasonable.
So outer days of remand are 90 days according to you?
Sorry, Your Lordship?
So maximum remand of PCR is 90 days according to you?
Maximum police remand is of 90 days, Your Lordship.
So there is no ceiling of 15 days?
15 days extended by the permission of magistrate for 90 days. And it can be extended till 90 days only. Not beyond that, because it would be ultra vires to the Article 22 of the Indian Constitution. Lordship, my last submission is that the competence was assured under Article 22 of the Indian Constitution after a very brief submission because
Come
of
to
time
prayers
constraint.
now.
Put the prayers.
Come to prayers.
Much obliged. Wherefore, in the light of issues raised, authorities cited, and arguments advanced, it is most humbly that the Honorable High Court of RM will be pleased to declare that the appeal is not maintainable before this Honorable Court, uphold the conviction of the appellant passed by the Sessions Court, declared that the trial in absentia was lawful, hold that the charge under section 375 of INS was correctly applied, and ultimately declare that the police remand was constitutional, and or pass any other order that this Honorable Court may see being fit in the interest of justice, equity and good conscience. For this act of kindness, the respondent shall be duty bound forever. Failure to argue before this.
We are supposed to sign as well? We will write. I have already got it. No problem. So should we sign this? Yes, sir. Are you sure? We have to sign, right?
There will be a high tea break now, and after that the final rounds will commence.
That we need for our lab. Yes. Now we can breathe for neck as well. I was supposed to write the bill or what? I was supposed to write the, it's fine, sir. Have tea, then final rounds. Yes, sir, yes. Since they have made all this submissions. So they have the same team have made the submissions. What we could do is we can fill them on citations. But sir, now when give only 15 minutes. Even issue can be there. Even issue can be there. Rest you come to now. That I will be qualified or not. That's a situation. We will just ask. Yeah, we will just go through the marks. You go through the marks. Yeah. Let's see if the Christ team is there, then I will go. If it doesn't go good. Madam, I will have to go now.
Guys.
कशासाठी
बसण्यासाठी
का बरं अच्छा आली आहे का येईल असं वाटतं
असं वाटतं
बघू तर खरे रिझल्ट